Hello students, welcome to TSAT. Welcome to the class on Indian Polity Group 1 TSPSC series. As part of the Indian Polity TSPSC Group 1 series, in the last class we have discussed about local governance. And to continue this series, today let us see one more important topic, and that is Indian Judiciary. Indian Judiciary. See, Indian Judiciary is very important because Indian Judiciary or judicial system is part of the major component in separation of powers theory in India. See, as per the separation of powers theory, the state is divided into three major components: legislature, executive, and the third one is judiciary. The main role of the judiciary is to review the laws. Now, on what basis judiciary will review the law is a question mark. On the basis of the Constitution of India. Judiciary safeguards the Constitution of India. Judiciary protects the Constitution of India. Judiciary is a guardian of Constitution of India. So, as it is a guardian of Constitution of India, every law made by the legislature is reviewed by the judiciary to validate it. Now, in India, the Indian judiciary is divided into a three-tier hierarchical system. The top of the all judicial system, we have Supreme Court, and bottom we have high courts. This is in state levels, and you have subordinate court in district level. We have one Supreme Court for the entire country. We have 25 high courts, and we have 600 plus subordinate courts, right? So, part 5 of the Constitution talks about Supreme Court, and part 6 of the Constitution talks about high court and subordinate courts. So, Indian judiciary or judicial system in India is always in news because of some Supreme Court or high court judgments, or majorly because of its judgments related aspects with parliament or legislature. So, judicial system in India is very unique and important because it is a guardian of the Indian Constitution. It protects the Indian Constitution. It ensures that everything in this country is aligned to the Constitution only, is following the Constitution of India. So, only it is called the protector of the Indian Constitution. Now, let us continue this Indian judiciary topic and see the first question. Yes. If you look at the first question, it says, consider the following and choose the correct statement. Indian judiciary is both independent and integrated. Supreme Court of India was formed on January 20th, 1950. Okay. See, let me reveal the answer first and explain this. Answer is C. Both the statements are correct. Yes. Indian judiciary is both independent and integrated. Now, what is the meaning of independent and integrated? See, whenever I say Indian judiciary is independent, this character of the independent judiciary is taken from US. This concept is taken from US, which goes along with the doctrine of judicial review. According to this doctrine, the legislative laws and executive policies or procedure in India is reviewed by judiciary to ensure these policies and laws follow the Constitution. Because Indian judiciary ensures everything is followed, everything follows the Constitution, it has to be independent. It cannot work with other components. Because it is a protector of the Constitution, it has to be independent. So, only Indian judiciary is called independent judiciary. Now, what is this integrated judiciary? Indian judicial system which is integrated is taken from UK concept or UK constitution. According to this, according to the integrated judicial concept, every law in India, whether it is a union law or a state law, can be enforceable by all the courts in the country, meaning every court in this country, including the district courts, have the authority to review and enforce any law in this country. This is the integrated system of judiciary. Now coming to Supreme Court. Supreme Court was formed on January 28, 1950. Now look at this carefully. See, it was in the year 1937. Federal Court was established at Delhi as per the recommendations given by Government of India Act 1930. So as per the recommendations of Government of India Act 1935, a federal court was formed in 1937 at Delhi, and this federal court was renamed as Supreme Court of India on January 28, 1950. And 1950 January 28, this federal court was renamed as Supreme Court. Okay, so this is your question. Both the statements are correct. Let's go to the next question. Consider the following and choose the correct statement. The Chief Justice of India appointed should be the senior most judge of Supreme Court according to Constitution. This is a key statement here. Very key word. Let me decode this. Article 124 to 147 deals with Supreme Court, which is part of Part 5 of the Constitution. Okay, this is a very simple question, simple statement. See, whenever if you see any statement which is tricky, the second statement will be very easy. Imagine this. See, absolutely this statement is correct. Now what about this statement? Yes, we all know that the Chief Justice appointed should be the senior most judge, senior most in terms of age, the first person to get retired. But is it according to the Constitution? No. Nowhere in the Constitution it is mentioned that the senior most judge of the Supreme Court should be appointed as CJA. This is as per a convention, or this is as per the Supreme Court judgments. We follow this, not as per the Constitution. Article 124 of the Constitution talks about the appointment of the judges, and nowhere it says that the senior most judge must be appointed as the Chief Justice of India. But after 1970s, we have seen that the Supreme Court made it mandatory for a senior most judge to be appointed as the Chief Justice of India by the President. So this is wrong. The answer is B. Now coming to this is absolutely correct. As I told you before, let me tell you again. Just give me a minute. Yes. See, we have three-tier hierarchical judicial system, integrated judiciary. The first one is Supreme Court, the second one is High Court, and the third one is Subordinate Court. Subordinate Court. Part 5 of the Constitution talks about Supreme Court, and you have Part 6 of the Constitution talks about High Court and Subordinate Court. Now in Part 5, Article 124 to 147 talks about Supreme Court. High Court, Article 214 to 231 talks about High Court, and 232 to 237 talks about Subordinate Court. So this is the constitutional provisions we have, 124 to 147. So the answer is okay. Let's go to the next question. Yes, expected for the exam because it is in news since very long time. Which article of the Constitution deals with contempt of the court provisions by Supreme Court? See, C and D you can straight away eliminate because these two articles doesn't belongs to Supreme Court only. So you have to see if it is Article 129 or 136. Article 136 of the Constitution talks about special leave petition. It deals with special leave petition. It doesn't talk about contempt of the court. Article 129 of the Constitution talks about contempt of the court, Supreme Court, and Article 215 talks about contempt of the court of High Court. This belongs to High Court, this is Supreme Court. Say contempt of the court is something when you go against the Supreme Court judgments or orders. And whenever there is a contempt of the court has all the rights to punish you. This contempt of the court is actually made applicable by Parliament law. As per Article 129 and 215, the Parliament has made a law in 1971 called Contempt of the Court Act 1971. According to this Contempt of the Court Act of 1971, there are two types of contempts. The first one is civil contempt, the second one is criminal contempt. When any person is disobeying the order of the Supreme Court and High Court, that is called civil contempt. Disobeying the order, disobeying the judgment, it is called civil contempt. When any person is defaming the court, defaming the judiciary, degrading the judiciary, it is called criminal contempt. For both, a person can be punished. Okay, so this is answer A. Look at the next question. Yes, consider the following and choose the correct statement. Okay, the judges of the Supreme Court and High Court are appointed by President of India after consulting Council of Ministers. The judges of the Supreme Court and High Court are appointed by President. This is correct. Up till here it is correct. After consulting Council of Ministers. No, this is wrong, because for appointment of the judges, presently a procedure is followed, and that procedure is called Memorandum of Procedure. This is MOP, right? According to Memorandum of Procedure, Ministry of Law and PMO, this is consulted. So this is wrong, not Council of Ministers. The judges of the Supreme Court and High Court are removed by the President, correct? After resolution passed in the Parliament, correct? This is correct. Answer is B. So according to Article 124 Clause 4, 124 Clause 5, these two articles deals with the removal process, according to which it says Parliament has to give a law for procedure to remove the judges of the Supreme Court and High Court. And did Parliament give a law? Yes. It said it gave a law in 1968 called Judges Enquiry Act of 1986. So Judges Enquiry Act of 1968, not 1986. Judges Enquiry Act of 1968, right? So this is your answer B. Okay, 2 only is correct. This is wrong because of MOP. We follow something called MOP, Memorandum of Procedure. Okay, let's go to the next question. Which article deals with the complete justice or curative petition? See, complete justice or a curative petition is a very unique thing followed by the Supreme Court, where all the parties involved in a case are given justice. Generally, not all the parties of the case are given justice, but here all the parties involved are given justice. Now this article, which article talks about complete justice or curative petition? And before that, let me also tell you, recently in Rajiv Gandhi assassination case, the person was released following the complete justice or curative petition. Secondly, Ayodhya. In Ayodhya case, Supreme Court has given judgment following the curative petition, and this curative petition or complete justice is discussed in article 142. This is expected question for the exam, most expected. Article 142 of the Constitution talks about curative petition. You all know article 136, I told you just before also, it talks about special leave petition. Now what is article 137? It talks about review petition. Article 137 talks about a review petition. 142 talks about curative petition, right? To tell you, right, in Ayodhya case, there are three parties involved. One, we have Ram Lalla Virajman, we have Nirmoyi Akara and Sunni Waqf Board. So coming to these three parties involved in Ayodhya case, following article 142 of the Constitution, all these three parties got justice. How? Ram Lalla Virajman was given the disputed land of Ayodhya, he was given that land. Sunni Waqf Board, the Supreme Court has asked the Allahabad government or I mean UP government or the government of India to provide 5 acres alternative land for Sunni Waqf Board, and Nirmoyi Akara was made a permanent trustee in Ayodhya Temple Trust. So all three got justice, that is the meaning, and this can be done as per article 142 of the Constitution. Let's look at the next one, right. Very important, which of the following is an incorrect statement? Incorrect statement. Someone who follows the current affairs will never put this type of questions wrong. They will actually make sure they can easily go through these questions. Look at the options. See, the question is which of the following is incorrect? The oath of the Supreme Court judges is administered by President. The oath of the Supreme Court judges is administered by President. Absolutely correct. The oath of the High Court judges is administered by President. I will come back to this. The oath of the subordinate court judges is administered by Governor. Correct. The salary of the judges of the Supreme Court is decided by Parliament. This is also correct. This is wrong. The oath of the High Court judges is administered by Governor. The Governor has the authority to administer the oath of the High Court judges, including the Chief Justice of the High Court. And who administered the Governor's oath? The Governor oath is administered by High Court Chief Justice. Okay, very, very important. So this is incorrect. Okay, let's go to the next question. Yeah. Consider the following and choose the correct statement. Consider the following and choose the correct statement. The acting Chief Justice is appointed by the President in case of the vacancy of the Chief Justice of India. The tenure of the judge of the Supreme Court is 65 years. Both the statements are correct. Both the statements are correct. See, who is an acting Chief Justice? A temporary Chief Justice. A temporary Chief Justice is appointed in the vacancy of the Chief Justice of India. Vacancy of the Chief Justice. Why will the vacancy occur? Due to a sudden death, maybe a resignation, a removal, and incapacity. In case of anything, if the CJA position is fall vacant, the President is authorized to appoint a Chief Justice, temporary Chief Justice called acting Chief Justice. The tenure of the judge of the Supreme Court is 65 years of age. This is also correct. And High Court 62 years of age. Okay. Now answer is both the statements are correct. Next question. Right. Look at the screen. Consider the following and choose the correct statement. Consider the following and choose the correct statement. The strength of the judges of the Supreme Court is decided by Parliament. The strength of the judges of the High Court is decided by Parliament. Answer is A. This is wrong. See, the strength of the Supreme Court judges is decided by Parliament as per Article 124. Article 124 says, until or unless Parliament decides, the strength of the Supreme Court judges shall be 7 plus 1, that is total 8. 7 judges, 1 Chief Justice of India. Presently 33 plus 1, total 34 judges are there. And the strength of the Supreme Court judges is decided by Parliament. Then why the second statement wrong? The strength of the judges of High Court is decided by the President time to time. It is not Parliament, it is decided by President time to time. Okay, so that's why this is wrong. Answer is A. Let's go to the next question. Yes. Consider the following and choose the correct statement. The High Court of both Madhya Pradesh and Odisha is in its capital. The Bombay High Court has its jurisdiction over 2 states and 2 union territories. I hope you guess the correct answer here. I am giving you 5 seconds time for you to think and guess the answer. It is not compulsory for all the High Courts to be in its capital, firstly. Secondly, second statement is actually in current affairs. So please think the answer. And if your guess is D, then you are correct. Answer is none. Both the statements are wrong. Why? See, Madhya Pradesh capital is Bhopal. But the High Court of Madhya Pradesh is in Jabalpur. It is in Jabalpur, not in its capital. Now Odisha capital is Bhubaneswar. And where is the High Court located? Cuttack. Not only this, if you look at Rajasthan, the capital of Rajasthan is Jaipur, but the High Court is in Jodhpur. The capital of Gujarat is Gandhinagar, but the High Court is in Ahmedabad. The capital of Uttar Pradesh is Lucknow, but the High Court is in Prayagraj, Allahabad High Court. The capital of Kerala is Trivandrum, but the High Court is in Ernakulam. So this area is where you need to learn more. Very, very important. And one High Court has its jurisdiction not only on one state, it can be in many states or on other states and also on other union territories. The second statement is actually correct till 2020, but after 2020 it is wrong. The Bombay High Court has its jurisdiction on 2 states and 1 union territory. Now what are these 2 states? Maharashtra and Goa. But UT, there is only one UT, that is Daman and Diu and Dadar Nagar Haveli. These both union territories got merged. As these both union territories got merged, we have actually one, not 2. I'll give you one more example. If you look at Calcutta High Court, see, Calcutta High Court has jurisdiction over 1 state and 1 union territory. Kolkata High Court jurisdiction is over West Bengal, Andaman Nicobar Islands. Chennai or Madras High Court, Tamil Nadu and Pondicherry. Ernakulam, Kerala, Lakshadweep. If you look at Chandigarh, very unique. Chandigarh High Court has jurisdiction over Punjab, Haryana, Chandigarh. So the jurisdiction actually differs. Now we have Jammu and Kashmir, which is a union territory, has its own High Court, Delhi High Court. So it is not compulsory that a High Court has its jurisdiction only for that particular state. It can be for more than that, more than one state, along with union territories. Secondly, it is not compulsory that an High Court should be in a capital. It can be in other places as well. Okay. Now let us go to the next question. Yeah, very important question, Amma. Consider the following and choose the correct statement. The rules for administration of the Supreme Court is given by Parliament. The rules of the administration of the High Court is given by state legislature. The office of the Chief Justice is under RTI. You know what is the answer? 3 only. Both the statements are wrong. This is correct. The office of the Chief Justice is under Right to Information Act. This is absolutely correct. I want everyone to remember this. Now coming to the first statement, or let me explain this. The rules of the Parliament is decided by Parliament only. The rules of the State Legislative Assembly is decided by Assembly only. The rules of the Council is decided by Governor. And the rules of the Supreme Court is decided by Supreme Court. The rules of the High Court is decided by High Court. And the rules of the subordinate court is decided by Governor plus High Court together. They decide the rules, the administration, how they are, how they perform, how they are, how they will be, etc. Very important for the exam. See, if there is any organization, that organization rules are decided by organization only. How they know better how to run that organization. No other outsider can have the rules, have the authority to decide the rules here. That is the point. Now let us see the last question in this series of Indian judiciary topic. So this is your Indian judiciary topic and related objective type questions. I will see you again in the next class with another topic on Indian judiciary for Group 1 TSPSC. Till then, happy learning. Thank you very much. Jai Hind.